All right, we are now recording and live streaming.
Okay, if everybody can go on mute until you're ready to uh, speak, and then you can, of course, unmute. Good afternoon, everyone. I'm Robert Hunter, the chairman of the North Carolina Property Tax Commission. We'll now convene this Monday, February the 15th, 2021 session. We're all virtual today, and we introduce others commissioners. Mr. Terry Wheeler is our vice chairman. Mr. Bill Peasley, commissioner. And Ms. June Michaud, commissioner. And today, our other commissioner, Alex Guest, is unable to join us. We also have with us Steve Pelfrey, our secretary and counsel. And we have Linda Garrett, who is our court hearing stenographer. And I think that's everyone that needs to be introduced so far. Let me go over the agenda briefly today. We have the first case is from Cherokee County. It's Michael and Maria I. Berlin and the 20 Property Tax Commission 0384. County is represented by Mr. Darrell Brown, attorney, and the appellate is appearing pro se, which means he's without counsel. The second case that was scheduled today from Johnson County, the Blackman Property Group case, has been settled. The third case from Wake County, Mr. Gregory, that case has been withdrawn. And then later on, we'll have a late or no AB 14 hearing from Dare County involving Mr. Benjamin Clark. We had one later, no AB 14 from Wake County. GFM, Roman numeral 2, LLC, that one has been withdrawn. So this case, full hearing, and then the one AB 14 from Dare County is our calendar for today. At this time, let me introduce from Cherokee County, Mr. Brown, and I believe you have your tax assessor with you. Is that Mr. Allen there with you?
That is correct, sir.
Okay, and then Mr. Berlin, you're with us as well?
That is correct.
Okay, well, what we'll do at first is we'll have, let me ask, Mr. Berlin, you did not submit any exhibits or anything other than your initial appeal, is that correct?
That is correct. I had to go out of town on an emergency, and unlike the county, I don't have 3 employees to come out and do stuff.
So are you still prepared to go forward this morning?
Yes, I am.
Okay. And
their exhibits are fine for me.
Okay. All right. Well, and at this time, what we'll do, we'll have opening arguments. We'll have you to first tell us about your case and just briefly about what it's about. And then Mr. Brown will have a chance to tell us from the county's perspective what the case is about. And then you'll have an opportunity to present your evidence and anything you'd like for us to hear. And then the county will present their case. So at this time, if you want to tell us, I understand there's no motions or anything pending, I don't believe. So we'll hear from you, Mr. Berlin.
Okay. I appreciate y'all today. What I've noticed when I looked at the properties close to my house is the county basically, in most cases, just came up with one figure and said that's going to be the figure for everybody's property. There is one example that in their comparables that does not meet that. But basically, they just said 45,000 for everybody. Now, I don't know if that's just being lazy or they truly believe that. 45,000 is an 80% increase in 6 years on my property. And I know that's not supposed to be relevant, but there are some other factors that are relevant. One of the main factors is if you look at my property that has my house, it is about a little bit more than a half an acre larger, and yet they're both worth 45,000. The one that has a half acre that is flat land. It does sloping to the river, and a slope that you cannot walk, by the way. When you look at one of their comparables, Sean Miller, basically the same thing, 45,000, and it again is a half acre larger, and it has a half acre flat land compared to mine, which just basically pretty much all goes down sloping, except for the area where if you were going to one day build a house, and we'll get to that in a minute. If you were going to build a house, all you would have room for was the house, and there's nothing flat land in front of it. It just slopes down to the river. Now, what that means is that for pretty much most of the properties, they're coming up with an acre price of about 21.6, 21.9, whereas on the lot that they've assessed at 45,000, almost at 29,000 per acre. And again, it doesn't have flat land that's usable. Now, if I was going to be using this property, you know, for doing something special, like growing timber or growing hogs or raising cattle, then yes, the price could be a little bit more. But the concept of intended use comes into play here. And this is a House Resolution 70 and 2475 back in 1991 by the Congress of the United States that says the intended use of a property can and does affect the value of the property. And this was a case of Columbia Hospital in Washington, D.C. Now, our property was purchased at fair market value in 2014 for $25,000. And the only thing this property for is to serve as a buffer zone. It is not to build a house, which would be its best use if you know, and I'm sure one day when I'm dead and gone, somebody may build a house on it. But my intended use is not for that. It's not to raise cattle. It's not to grow timber. And it does, because of that, the intended use of the property, according to the Congress of the United States, states that you will take that in consideration, not just the fact that you're doing that. The best use of the property for today. Now, they looked at a couple, what they say comparables. There's a comparable on Paradise, which is—
Mr. Berlin, let me stop you for a minute. This is kind of the opening statement, and when you get into presenting evidence, you probably need to show us exactly what you're talking about.
Okay.
I think you said you were going to use their exhibits, so you can talk in generalities, but if you get into specific things, it'd probably be better if you point us towards those when you have a chance to present your case, which will be in just a minute.
All right. Well, in general, then, they're charging more per acre for my lot than, and I'll let them answer now and start.
All right, Mr. Brown, opening statement for you on behalf of Cherokee County.
Good morning, good afternoon, Mr. Chairman and members of the commission. I have a couple of motions before we go into the presentation of evidence. First being—
Okay, I'm sorry, I didn't realize you had any. I mentioned that, but I didn't hear you. We'll go ahead and tell us what they are, and we'll try to dispose of those.
Yes, sir. Thank you. Pursuant to 17 NCAC 11.0214, due to the fact that the appellant failed to enter into the required pre-hearing order and failed to provide any evidence or names of witnesses, we would respectfully move to dismiss his appeal.
Well, he said he wasn't going to have any witnesses or any exhibits. He was going to use yours. So why don't we go ahead and we'll deny that motion, Mr. Brown.
Then,
If he were going to use something else, we had ruled it out of order.
then for the record, I would be making, under the rules of evidence, a motion in limine to preclude him from using any of the respondents' exhibits or witnesses in the presentation of his case in chief, as he did not provide any of those to us as going to be used in his case in chief. And that would be not including but not limited to any of our marked exhibits that we provided in a timely manner, and any of the witnesses that we identified that we would call.
Well, again, he's only using his own testimony, and I think he'd be entitled to call your witnesses. He should have listed them, and he should have joined in the order, but I'm going to go ahead and deny it at this stage.
I would at this time waive any opening statements and agree to go ahead and proceed with the presentation of evidence.
Okay, and we'll note your objections to my rulings.
Thank you.
Okay, Mr. Berlin, they've waived their opening argument, so you may proceed now, and you're entitled to offer evidence, and you're entitled to testify now. So you're under oath for this part of it.
I do appreciate that. And I'm not an attorney like the gentleman there is, so I don't understand all that legalese that he talks about, but I appreciate you denying his request. I have a question, and I don't know if they can answer this at some point, but and they're number 12, what does my appeal is baseless mean? Is it their opinion, or what does that mean? I don't understand.
Well, that's in their pretrial conference. You were supposed to have a pretrial conference with them, and that would have been a good time to ask them about that. But that just means that's their argument about your appeal, and they'll probably get into that further after your testimony.
All right. Okay. As I had said earlier, the property that is under dispute here, they have it valued at almost 40% more than the other properties based on the acreage. The property that's in dispute does not have as much flat land or usable land as my home property, the Miller property. They have another property.
You want to identify what you're talking about, Mr. Berlin?
Okay, it's the Sean Miller property, and they have 1,000, and it's 2.5 acres, which comes to 21,951 an acre.
Now, what are you talking about, Mr. Berlin? You're going to have to point us to what you're referring to. Are you referring to their exhibits?
Yes, sir.
Because you did not send any in.
No, sir. That's their exhibit.
Which?
Oh, good Lord. I didn't look at exactly which one it was. I can look it for you. You'll give me a second. The Sean Miller is their last exhibit.
Which one is that?
That would be, let's see, I'm trying, he's marked. I think it's 11A. No, exhibit 12, I'm sorry. Exhibit 12.
All right. Exhibit 12, okay.
And 2.05 acres. valued at the same as mine, which means it's basically about $8,000, $7,000. So you're talking over a 35% difference right there. If you look at the property owned by Mr. Panico, and I will have to get that exhibit.
And I don't believe you told us how much you thought your property should be appraised at. I saw it someplace, but you need to get,
32.5 is what I had said.
all right.
Let me see here. These things are hard. I don't know.
Do you have a hard copy of their exhibits?
No, I don't have a printer. And again, I had to go out of town on an emergency and just got back in.
All right.
So I didn't really have time to take it to someplace. All right, the Panico is state exhibit number 8, and it's 2.18 acres. And the used at 500, which is $10,321 per acre. Now, they have some other exhibits which really aren't comparable. And I'll give one is Buck on Paradise. Because Paradise sits right on the river, and the whole property sits on the river. And Lord have mercy.
Mr. Chairman, I think he's
Yes,
trying to
Mr. Brown.
find exhibit number 2.
Number 2,
And I
I
believe
believe
it's the Buck property on Paradise. And
it's
Paradise
number 2.
is even
Exhibit number 7.
because it sits right on the river, and the whole property sits right there, and it's flat land right there at the river. So that would not even be considered comparable. My house sits up a couple hundred feet above the river, and the lot that is next to it, if there was a house there, it would sit the same way. So my basic thing is the intended use of my property should be taken into consideration, and also their own comparables. They do not compare, and that the property shouldn't be valued as much as what it should be. And I'll be interested to see exactly what they say, but that's pretty much my argument. And I'll mute now, and they can do their talking again. They can let their lawyer do their talking.
all right.
Oh, I do have a question. How come they came out to my house? They took all these pictures, 3 employees, and not one of those pictures is in there. But that seemed like another waste of government money.
All right, it's their time to cross-examine you after you've testified, Mr. Berlin, so we'll call on Mr. Brown.
All right, go ahead.
No questions.
All right, Mr. Brown, they've said they don't have any questions of you. Is there anything else that you would like to point out to us before you finish your part of your case? As far as evidence or anything, you'll have a chance to argue a little bit later at some point. Anything else, Mr. Berlin?
No, sir, I do not.
All right. So you finished your case then. There's no evidence, no exhibits or anything to admit that, from that standpoint. Are you wanting to admit their evidence, their exhibits that they've talked about, that you've talked about?
Yes, sir, that'll be fine.
All right, we'll admit their exhibits, which are already in order, and normally we admit everybody's exhibits unless there's an objection. Okay, Mr. Brown, for the county.
At this point in time, I would respectfully make a motion to dismiss at the close of the appellant's evidence for failure to state a claim for which relief can be granted. The evidence does not even rise to the level of being a prima facie case of adjustment in this case.
Okay, Mr. Berlin, the county's moved to dismiss your appeal because of failure to, there's a presumption that you have to meet, and so they've moved to dismiss and that you have not met your presumption.
Can you explain to me what that means?
Well, it means you have to show that their appraisal is arbitrary or what's the other term? I'm thinking arbitrary or and it, Steve, help me, arbitrary or
Sure. The appellant is to demonstrate that the county's value is arbitrary or illegal and that it substantially exceeds the true market value.
Right. I was forgetting illegal. Thank you. All right, Mr. Brown, you've heard an explanation there. The county is arguing that you did not meet that burden with your evidence. Now, you have a chance to respond and to argue that we should deny their motion for you would have to show that you have met that burden. So would you like to comment on their motion?
Well, I would like to comment on it. I'm not so sure why a 30-some-odd% difference in the property is not arbitrary. That's property. You're looking at a half an acre and less property, and why that is arbitrary. I mean, why you're saying it's arbitrary and that I have no basis, I do not understand. Because a half an acre is a half an acre, and it's a half an acre of flat land compared to land going straight down that you couldn't walk if you wanted to. Now, it could be that those young men there could walk down there. I don't know. I did when I first moved here. I couldn't do it now. And I do not understand why you could say it's arbitrary. I mean, why my thing is that, because I think I've showed that there's a big difference in the values of this property compared to other properties that should be similar. And that's I guess my biggest thing right there is I just don't understand how they're saying that. You're looking at, and I'll give you the exact figure in just a second. About a 30% difference in the value of the property from the Miller property and from my own other property that my house sits on. And they've got my property valued twice as much as the Panico property, and yet it's even small. It's almost, it's probably about almost 150% difference. So why they're saying, I do not understand how, I mean, I think, so I can't understand it. I mean, 20% may not, 20 to 30% may not be that much to some people, but it's a starting point. And
All right.
every single property except for that one, Panico. They made them all 45,000. Didn't matter what the properties looked like, where the property sat, the size of the property. So that's my argument, sir.
All right, so we'll go into executive session and go offline to deliberate on the county's motion that we should dismiss. And then we'll come back and we'll have a ruling as soon as we're able to determine that motion. Okay, Ms. Bendette, will you take them out of our session, and then we'll be back and be back in public session as soon as we finish hearing the motion.
I'll hang up,
Voting on
Mr.
the motion.
Berlin.
Okay.
Yep, give me just 1 minute and I'll get us in a
Let me ask
private
before we
session.
get off, I didn't see any commissioners, didn't hear you asking for any questions or raising any hands. Did any commissioners have anything they wanted to ask? Okay, all right. Go ahead. Then.
Mr. Chairman, do you want me to keep Linda in or?
Either way, that's fine.
Okay. All right, we are back and we have everybody back in the meeting. Oh, hold on 1 second. You automatically mute when.
All right, I think we've got everybody back, except I don't see Mr. Brown or Mr. Allen. Can y'all give us your video? I see Mr. Berlin. I see all of our commissioners, I believe.
There we go, I think.
There you go. Thank you, Mr. Brown. Okay, the commission has deliberated on the county's motion that, Mr. Berlin, you've not met your burden of showing that their method was either arbitrary or illegal, and it was in substantial excess of the true value of your property. The commission deliberated on it, and with unanimous decision, the commission has granted the county's motion to dismiss. Mr. Berlin, you have to show more than what you did, and also it's not the intended use of your property. In North Carolina, the statute for property tax evaluation is its highest and best use. So that's how it's valued. There's some exceptions to that, but that's not, yours is not one of those exceptions.
Can I ask just one question?
Sure.
And I know you've already decided, but why is a 33% difference not substantial?
Well, we'll have a written opinion for you, and we'll try to set that out in the written.
But I'd like to know what y'all's thinking was on that. If someone could at least explain it, but I can't understand why a 33% difference wouldn't be substantial. And if someone can explain it, I'll leave. But can someone explain that to me? Even maybe the attorney. I just wanted to explain why a 33% difference is substantial.
Steve, do you want to comment, or we can do it in the opinion if it.
Well, I don't say specifically in this case because I don't have full information, but there are situations where the market indicates that buyers aren't really concerned about some differences from one property to another. For example, in a subdivision, you might have lots that are all to a greater or lesser extent, different sizes. And in spite of that, everybody's still typically paying about the same amount for all of these lots. And so if there's no market evidence that differences in size make a difference, then an appraisal or an appraiser might look at that situation and say, well, there's really no point in putting that fine of a point on it, because the market just doesn't seem to recognize that. That's not to say that there can't be differences between the properties, or that the market might not find differences between the properties based on distinctive features. But it can happen that buyers aren't particularly concerned about that sort of thing. And again, this is all theoretical, because I don't know the specifics of this case, but
When you're talking about buyers, you're talking about an appraised value as opposed to an assessed value. Isn't there a difference?
there is not. No, sir. North Carolina, the value at which the value are assessed is typically the same as their appraised value.
And it's the highest and best use. Okay, we'll try to maybe set out a little more, Mr. Berlin, in the written opinion that you should receive, certainly within 90 days. All right, Mr. Brown, thank y'all. Anything else from y'all?
Nothing further from the county. Our thanks for your consideration.
Okay, Mr. Brown, was your dad the highway patrolman, Sergeant Brown?
Yes, sir.
I thought I remembered that from when you said you were in McDowell County. Mr. Vice Chairman Wheeler, Terry Wheeler used to be a highway patrolman. All right, thank y'all so much. And we've got one more matter to hear. You're welcome to stay on if you would like, but not as a participant. You would be part of the public.
Thank you.
Okay, we have one more item on the agenda today. Let's see, I think there's some people. Do we need to admit the people from Dare County that wanted to observe for this matter, Steve?
Mr. Chairman, it really just depends on whether or not, I'm sorry, I don't know if I saw I don't know if that came through. It really just depends on whether or not the commission wants to hear from the county. Typically this is an administrative thing. So typically this is really just a discussion between the commission and the appellant. But if you'd like to hear from the county, then that's certainly an option.
Well, let's admit them, and then that'll be an option so that they can be participants in case they want to. Normally we don't have anybody from the county, but since they're here, and I think they have a case, or do they? Do they have a case anytime else on the? No, I don't guess so.
Yes, that's the Dare County case.
Yes, but I mean another one. Do they have? That's the only thing they have, I believe.
That's right. That's the only thing on for this month.
Yeah. Okay, so who do we have from Dare County? Hosea Wilson, is that?
Yes, sir. I'm the
Who's
county.
on?
Yes, sir. Can you hear me?
Yes.
Can you hear me?
Yes, sir. Can you identify yourself, Mr. Wilson?
Yes, sir. I'm Hosea Wilson. I'm the county assessor for Dare County.
All right. Anybody else from Dare County with you, or just you?
Just me today, sir.
All right. So we'll call the next case, which is from Dare County. It's 20 Property Tax Commission 0489, in the matter of Benjamin Clark and a late or no AV 14. Mr. Pelfrey, we'll hear from you as to this matter.
Thank you. On November 10th, 2020, our office sent a letter to Benjamin Clark acknowledging receipt of a notice of appeal filed with the commission on November 4th, 2020. In addition to that letter, our office sent copies of Form AV 14, complete with instructions, and a a notice of the requirement to complete all portions of that form and to return it to the office within 30 days of the date of the letter. Again, that letter was dated November 10th, 2020. At this point, we have not heard anything further from the appellant in this matter. And on, excuse me, one. December 9th. On January 26th, our office sent notice to the parties today's hearing. And again, no response from the appellant in this matter.
All right, questions from commissioners? Hearing none, there's no reason to go into executive session on this. Do I hear a motion that we dismiss this matter?
I'm not sure. I just want to make sure that was the taxpayer
Yep.
notified to be here.
Yeah, you said that, I think.
he
didn't you,
did.
Steve?
I apologize.
Yes, sir.
Didn't you, Steve?
I did by letter dated
January.
January 26th. Everybody was given notice of today's hearing.
Okay. I move to dismiss.
Okay. Commissioner Peasley moves to dismiss, seconded by
I'll second.
Vice Chairman Wheeler. Hearing no further discussion, all in favor say aye.
Aye.
Opposed nay, and ayes have it. It's unanimous, Ms. Garrett. All right. Mr. Wilson, we're glad you joined us today from
Sir,
Dare County, and I'm sure Mr. Wheeler might want to say hello. Anything you want to say, period, before we go offline to your Dare County citizen and public servant?
No, I just know what they have been through with the pandemic as we have, having to go virtual. I know that Dare County has done a lot in that arena so far to keep things moving along as best they can. I think they got the same situation we have. If somebody wants an in-person hearing, they've been put on hold for a while. Otherwise, virtual is what we're all doing right now.
that is correct.
Hey, let me ask, I've had my first shot. My second was scheduled for Friday, and I was out of town, and mine has been rescheduled to this Thursday afternoon. Who else? Terry, you had both yours?
No, I get mine the 24th.
First or second?
Second,
Second.
24th.
I get my second one on that same day,
All righty.
the 24th.
Bill, have you had yours?
No, I'm not. I don't qualify.
Okay. All right. How about, let's see, that's it, except for Steve and Linda. And I don't think they probably qualify either. Let's briefly, we'll talk about tomorrow's agenda. Steve just told me earlier that HMM Hospitality, they've had someone who's tested positive and in quarantine. I believe it's the attorney, Mr. Moorfield, and so that one has been continued. Then we have the Dare County, the Ashley Furniture Industries motion to continue.
Davie County.
Davie, I'm sorry. I looked at it and knew it said Davie and said Dare. Steve, is that the one that has a confidential file with it?
Yes, sir. And just to clarify, that is a motion to compel. The appellant is requesting information from the county.
Oh,
right.
Yeah, I did. Motion to compel, not continue. I saw that C. Okay. All right. That would make sense because we would have disposed of the motion to continue. All right. So that's regarding evidence, and I assume that's what we have the confidential information matter about. And then the other case, Durham County has been settled, and we have the county from Iredell County matter. Did I hear somebody?
No, just Iredell.
Iredell. Yeah, that's the last case. Durham is settled, and Iredell County is Mr. Frank DeFelice, and that's another pro se. So that's tomorrow. Wednesday, everything has been settled or withdrawn or continued except for the Red Pat leasing, I believe. And then Thursday, we've got the Burns motion to dismiss and the Greenville Mobile States motion to dismiss. Those two motions to dismiss for Thursday. Steve, anything else before we adjourn?
No, sir, nothing more for the record today.
Anything we need to do once we go off the record? All right, then we'll see you in the morning at 9 a.m. Thanks, everybody.
Thank you.
Thank you.
Have a
Bye,
good
thank
afternoon,
you.
everybody. Thank you.
You too.